Welcome to Holland & Hart's legal update for COVID-related issues. We do this every Monday, and we wanted to give you an update concerning issues and developments that have occurred over the last week or so. My name is Kim Stanger. I'm the co-chair of the firm's health law group. I'm joined today by my partners Christy Kimball, Brad Cave, and also Jay DeVoy. I'll go ahead and start with some of the hot topic issues, and then I'll turn the time over to Brad Cave. The one that's probably on the most of our clients' minds is the Provider Relief Fund payments that came out around April 10th. As you may recall from our discussion last week, there was some uncertainty concerning the scope of the person's ability to receive and keep that $30 billion total payments that went out to them. Among other things, the recipients are obligated to do an attestation that they comply with certain terms and conditions. Last time we spoke, we did not have that attestation open yet, but now the government has put that up on the portal. It's at their website, hhs.gov/provider-relief. If you can go there, there will be a link that will allow you to go in there and do that attestation as part of the condition in order to retain that money that you may have received. Now, that attestation, you're required to do that within 30 days of the date that you received the payment. But the terms and conditions state that if you fail to do that attestation, that you're deemed to have complied or accepted those terms and conditions regardless. Probably safest if you intend to keep that money to go in there and do that attestation. In addition, the other really significant event that occurred is the government updated those terms and conditions. As originally stated, as you know, in order to maintain that money, you've got to certify certain things. One of those things that you had to certify is that you billed Medicare in 2019 and, as originally promulgated, that you currently provide diagnosis, testing, or care for individuals with possible or actual cases of COVID-19. Obviously, that created problems for healthcare providers that may have shut their doors or stopped performing elective surgeries, and therefore they may not have been able to do the certification. Last week, the government updated those terms and conditions to remove the language currently providing diagnosis or testing. So now you have to certify that you provide or provided after January 31st, 2020, diagnoses, testing, or care for individuals with possible or actual cases of COVID-19. That seems to broaden up the scope of the Provider Relief Fund significantly. It seems to open the door to payments, to receipt of those payments, even though you're not currently provided diagnosis, testing, or care for individuals consistent with the statements that were otherwise made on the HHS website. For example, on the HHS website, if you go within there and look, they describe the scope of that relief fund as this funding will be used to support healthcare-related expenses or lost revenue attributable to COVID-19. In addition, this quick dispersal of funds will provide relief to both providers in areas heavily impacted by COVID-19 pandemic and those providers who are struggling to keep their doors open to healthy patients, delaying care and canceling elective surgery. And it also states if you ceased operation as a result of COVID-19 pandemic, you are still eligible to receive funds so long as you provided diagnosis, testing, or care for individuals with possible or actual cases of COVID-19. On the website, they clarify that the care does not have to be specific to treating COVID-19. HHS broadly views every patient as a possible case of COVID-19. Well, that language seems to open up the door to allow other entities, other specialties who may not have been primary care providers or hospitals actually involved in directly treating patients with COVID-19. But we're still waiting for guidance on that. It still indicates, or the language seems to suggest, that there still has to be some nexus with providing COVID-19 treatment. For example, some of the other terms and conditions are you can only retain the money for COVID-19 related expenses. But the bottom line is we're going to have to continue to monitor that. Among the other conditions that you have to certify is that the recipient certifies that the payment will only be used to prevent, prepare for, and respond to coronavirus and shall reimburse the recipient only for healthcare-related expenses or lost revenues that are attributable to coronavirus. And the recipient has to certify that it will not use the payment to reimburse expenses or losses that have been reimbursed from other sources or that other sources are obligated to reimburse. Now, the key takeaway, I guess, from today is if you did provide diagnosis, testing, or care for COVID-19 patients after January 31st, 2020, even though you are not doing it now, chances are you're going to be able to accept and use that payment. As for others, if you're a specialist, maybe an OB, maybe a podiatrist who was not really involved in specifically treating COVID-19, that's a little bit more iffy. I think the language on the HHS website that extends where they state that you don't have to be treating COVID-19 patients directly, and they view the conditions broadly as applying to all patients as possible cases of COVID-19. I think that may open the doors for you to claim and retain that money. But again, I would make sure that you watch that. In the meantime, it's very important that you document the expenses that you are incurring and the losses that you have that are related to coronavirus, because you're going to have to submit reports in order to justify your receipt and retention of that money. We did not get a lot of additional guidance concerning those reports, so stay tuned for that type of stuff. You're going to also have to carefully document which funds you used to pay for those expenses so that you can confirm that you have not used other funds that are related to CARES or would reimburse you for the COVID-19 expenses. You can't double dip, so you're going to have to track that. If there's any question about your ability to receive those funds, again, I would go back to the comments we made last week, which is put those funds in a separate account until you get more guidance so that if you do have to repay, that you can. If you ultimately determine that you are not entitled to that money, then you're supposed to contact HHS within 30 days of receiving that payment to make arrangements for the return. So, good news is it's broader. Bad news is we still need further clarification on some of that guidance, so make sure that you pay attention over the next week or two. As for the remaining funding sources, there's still the $70 billion that are allocated to the Provider Relief Fund. We have not gotten any additional information concerning how or when that is going to be dispersed, so we need to pay attention to that. The Congress is still haggling over additional funds that will come out. Presumably there will be another round of Paycheck Protection Program loans that are coming out. Most of that money I think has all been used up already. The Democrats are pushing for broader funding sources. I think that there's general consensus that they need to allocate more money for that program, and it's just a question of how broadly they're going to do it and whether or not they're going to make it available to on a priority basis to certain other entities. A couple of other items real quickly. In the Long-Term Care Fund on April 13th, CMS provided supplemental guidance for long-term care facilities for purposes of cohorting them based on COVID-19 status. Under this updated guidance, licensed LTC facilities generally can transfer or discharge residents to another certified LTC facility without state agency approval. The guidance indicates, however, that the transfer or discharge of a resident for COVID-19 cohorting purposes to a non-certified LTC facility does require state agency approval. The guidance builds on recommendations that CMS issued on April 2nd on mitigating the spread of the virus in nursing homes, including designated separate facilities or units for residents based on their COVID-19 status. So if you operate a long-term care facility, you should check out that updated guidance that came out on April 13th. Also, OSHA issued additional guidance on April 13th that prioritizes enforcement activities during the COVID-19 pandemic on those workplaces with high risk of exposure to the virus, such as hospitals, nursing homes, emergency responders, home or hospice care, and biomedical laboratories. This guidance indicates that OSHA will focus inspections on these high-risk settings. Formal complaints alleging exposure to the coronavirus in medium or lower risk settings normally will not result in an on-site inspection. In these cases, OSHA instead will use non-formal procedures to investigate alleged hazards, though an on-site inspection is possible if the response is unsatisfactory. The guidance also details information about the scope, schedule, and procedures of inspections. So for you employers out there that have OSHA concerns, make sure that you're aware of the updated OSHA guidance. Those are the items I had on my list. Brad, I turn it over to you to talk about some additional items.
Sure, Kim, thank you. And I'm going to touch on 3 items today. I'm going to pick up on another OSHA-related topic in addition to what Kim suggested, or in addition to the topic Kim talked about. I'm also going to talk about some additional EEOC guidance that came out on Friday, and I'm going to talk about furloughing employees, in particular furloughing exempt employees, and what options are available to you to do that without threatening their exemption from overtime and from minimum wage. So going back to OSHA, as Kim mentioned, OSHA has issued some enforcement guidance focusing on when they will conduct inspections in the healthcare arena. I want to go back and talk about the record-keeping requirements for healthcare employers. OSHA issued some broad exemptions for record-keeping related to COVID-19 reports of illness. However, they specifically said that healthcare employers continue to be covered by the pre-existing record-keeping and reporting requirements. So just by quick way of review, healthcare employers are still required to log on their OSHA 300 log all confirmed cases of COVID-19 that are work-related and that involve really any kind of medical treatment beyond first aid. So that would include any kind of days away from work, any kind of restricted work duty, or transfer to another job. It would also require any medical treatment beyond first aid, and of course, any hospitalization. So as a result of those basic requirements, which have been in place prior to COVID-19, the issue that most healthcare employers will face if they have a COVID-19 claimed illness is whether this resulted from exposure in my workplace or whether it was a result of exposure elsewhere. Your infection control folks, if you're a larger employer, may well be tracking who's been working with COVID-19 patients if you have COVID-19 patients in your facility. But one way or the other, an employer who's faced with a claim that from an employee that they have employment-related COVID-19 will need to determine whether that is a result of a work-related event or exposure, or a work-related event as contributed to or significantly aggravated a pre-existing injury or illness, and make a determination under OSHA's regulations about whether that event is a recordable event. Now, in addition to recording those illnesses on your OSHA 300 log, the Occupational Safety and Health Act also requires that you report certain events. So if you have a COVID-19 diagnosis in your facility and the employee ends up being hospitalized, you must report to OSHA within 24 hours after the hospitalization of that employee, subject again to a conclusion that it is or it may be a work-related exposure that caused the COVID-19. But then you have to, in addition to your record keeping, in addition to your OSHA 300 log, once that hospitalization occurs, you have to report it by telephone or through the internet provided method to OSHA. You also obviously, if the hospitalization leads to the death of an employee, the death also has to be reported. In the event you're not aware that an employee has been diagnosed with COVID-19 because either they're on leave or they haven't notified you until sometime later, you have 24 hours to if they've been hospitalized, you have 24 hours after learning about the hospitalization to notify OSHA. If they have deceased from COVID-19, you have 8 hours after learning of that to notify OSHA. So these timelines are pretty strict, and unfortunately, healthcare employers are not exempted from these timelines as many other employers are. All right, let's talk about EEOC guidance. We touched on EEOC guidance last week. The EEOC has, about on a weekly basis, roughly has issued new Q&As that they've used to supplement their Q&A document. Their focus on the Q&As released on Friday continues to be in large part on the accommodation process. If you have employees in the workplace that have disabilities, you may have accommodation requirements that have arisen because of COVID-19 that may not have existed prior to COVID-19. You may have to change the accommodations you're providing to employees who have disabilities because of COVID-19, or in the situation of an employee who's returning to work either after recovering from COVID or who's returning to work, but the presence of COVID-19 patients change their risk profile because of some other underlying condition. You may need to provide accommodations in those cases. The new questions from the EEOC essentially reinforce that employers have the right to ask questions about an employee's claim or request for accommodation. You can ask questions like, what is the disability? How does it create a limitation? How will the accommodation you want effectively address the limitation? Whether there's another accommodation that we could provide that would also effectively address the limitation, and how will the proposed accommodation enable you to perform the essential functions of your job? So EEOC is reinforcing that we still follow the accommodation process. They have given some flexibility with respect to the timing of that process. The EEOC in one Q&A affirmed that employers can temporarily institute accommodations without being bound to those accommodations indefinitely. They can do that when, because of COVID-related issues, they may not have the resources or the time to conduct a full needs assessment to fully investigate whether the accommodation is necessary or effective. In other words, they can take the employee's word for what the employee wants, implement it, and then come back later when things have calmed and study whether that accommodation is the appropriate one without being bound to their original temporary decision. Obviously, if you're going to do that on a short-term basis, it's important to communicate very clearly and in a documented form with the employee that this is a temporary agreement to the accommodation you've requested, but we reserve the right to come back and investigate this more fully when we're provided, when we have more time to do so. The EEOC Q&A also authorizes employers to be proactive in asking employees who are out for COVID-related leave what accommodations they may need when they return to work. I think this will be very important for healthcare employers because your people who are coming back to work after COVID-19 or after taking leave because they're highly susceptible to COVID-19 will have some accommodation issues. There may be alterations to the workspace. There may be obviously personal protective equipment requirements. There may be schedule modifications that might be appropriate. And the EEOC is encouraging employers to begin that discussion as early as you possibly can, even before the employee has been released to return to work. The Q&A provides some additional texture to the undue hardship restriction, or the undue hardship exception to the accommodation requirement. The accommodation requirement is a big, broad requirement for employers. It's limited by undue hardship. Prior to COVID-19, for most employers, it was very difficult to argue undue hardship as an exclusion to an accommodation requirement. The Q&A recognized that for some employers, not just healthcare, but some of this applies specifically to healthcare. For some employers, the business conditions caused by COVID-19 may very well create undue burden, undue hardship, and limit the accommodation requirements depending on what that accommodation is. The undue hardship considerations arise when the requested accommodation poses a significant difficulty for the employer, and that may be measured by financial significant difficulty. It may be measured by staffing. It could apply to requested changes in job duties of a person who's coming back related to their COVID-19 diagnosis or their susceptibility to it. So the questions have taken a relaxed view of undue hardship or undue burden, and have specifically recognized that the loss of some or all of an employer's income stream is a relevant consideration in deciding whether undue burden excuses the employer in a particular situation from providing accommodation. This is not a blanket get out of accommodation free card. You still have to approach each employee request for accommodation individually, and the undue hardship, undue burden test will be applied on an employee by employee basis. You don't get a healthcare exclusion from the accommodation requirement. You just simply, in this case, get to take into account those things I talked about earlier: staffing considerations, income reductions, etc. And finally, on the EEOC topic, the Q&A gave us some more guidance on direct threat. CDC has declared that COVID-19 is a direct threat for ADA purposes. So obviously that means that anybody who has COVID-19 or COVID-19 symptoms, you don't have any duty to accommodate them in the workplace as long as until they are rendered clear of those symptoms and are no longer able to pass along the virus to others. On the return to work question, I think a lot of you may be faced with questions in your mind about how do I bring somebody back to work who may have had a COVID-19 diagnosis. What do I do? How do I go through that? The EEOC has made it clear that if you follow CDC recommendations, you will be in compliance with the ADA. So even when employees want to come back to work, they want to come back to work because they're probably on unpaid leave, they're able to return to work, but you can still follow CDC requirements before returning that person to work. And kind of the final Q&A was relating to the personal protective equipment that employers may require employees to use when they return to work. The Q&A recognizes and reminds employers that you may have an obligation to accommodate people with respect to their PPE when it interferes with their religious practices. For instance, if they're required to wear a beard, or they're required to wear a certain headdress or a headwear of some sort, or there may be other physical or limitations that relate to the PPE and you have to engage in the interactive process to figure those things out and come to the right conclusion that allows a person to return to work. All right, let's talk about furloughs. for a moment. I've talked to probably half a dozen of my healthcare clients who are considering or are implementing furloughs. The wave of COVID-19 patients simply hasn't arrived, and because of the cancellation of elective procedures and closing of physician clinics and other related facilities, the clients simply don't have the work for their staff to do at this point in time. Furloughs raise some implications under the Fair Labor Standards Act. So it's important to keep those in mind as you're thinking about furloughing employees or you're doing so. If we're talking about hourly non-exempt employees, in other words, employees that are paid on an hourly basis that are not entitled, or that are entitled to overtime, in other words, they're non-exempt from the Fair Labor Standards Act overtime requirements. Those employees are paid for what they work. It's easy to furlough them. If they're not working, they're not getting paid. The tougher question is, do we allow them to use accrued PTO? I suggest that your policy controls that question. If you have a low census policy, if you have PTO policies that address that and that you need to follow those policies. You could adopt an exception to those policies if you're allowed to do so under your state law, but that's going to be a question of policy for your hourly non-exempt employees if they're furloughed. The bigger and trickier question is when you furlough salaried exempt employees. Salaried exempt employees are, with one key exception, are required to be paid on a salary that's established in advance and that they're paid week in and week out, regardless of the quality or quantity of their work. So if you have a salaried exempt employee, let's just pick one. Let's say your billing manager, for instance. That's probably not a good choice because your billing manager is probably still working. But let's say you have a practice manager in one of your clinics. That person is salaried exempt. They're paid a determined amount of salary every week, whether they work 3 days, 5 days, or 6 days, whether they work 4-hour days or 10-hour days, regardless of the quality and quantity of work. And that's a requirement in order for them to be treated as exempt. Employers of all varieties can compromise that exemption if they dock exempt employees' salary for reasons related to quality or quantity of work, including usually reasons relating to the employer's business conditions. However, there are some options here. If you are going to furlough salaried exempt employees, you can furlough those individuals for an entire work week. I'm not talking about your pay period. It doesn't matter how you pay, whether you pay bi-monthly, semi-monthly, bi-weekly, monthly. I'm talking about work week. Your policy should define a 7-day period, consecutive day period. That is your work week. That's the same work week you use for counting the number of hours somebody works to determine if they're entitled to overtime. So if you furlough a salaried exempt employee, you can furlough them for the entire work week, and provided they do no work during that work week, you can not pay them for that work week. So that's one option for furlough. The second option, because that one doesn't always work very well for salaried exempt employees because they don't tend to furlough very well. They tend to do their responsibilities even as being furloughed, which violates then the salary basis test if you don't pay them for the entire week. So the second option, prospective reductions in salaries. The Wage and Hour Division of the Department of Labor has issued a fact sheet on prospectively reducing the salary of exempt employees without destroying the exemption, or in some cases, destroying the exemption only for the week in which the salary is reduced. This can be done because of budgetary difficulties for the employer, but it cannot be done on a week-by-week or day-by-day basis. In other words, you're faced with a set of conditions right now that may last for a period of several weeks or months. under the Wage and Hour Division's guidance, you can say to your salaried exempt employees, we are reducing your salary by 25%. We're reducing your work schedule by 25%. This reduction will remain in place until the pandemic is lifted or until some event that allows us to return to normal operations. So you can do it in that fashion, and the Fair Labor Standards Act the Wage and Hour Division has indicated that if you do that in good faith, in a way that is not intended to avoid the salary basis requirement, you will not compromise the exemption before and after you raise the salary back to pre-reduction levels. There is another special rule for public agencies. If you're a public hospital and you meet the definition of a public agency under the Fair Labor Standards Act, you can deduct from salaried exempt employees' pay due to a budget-required furlough, and as long as that they do not work, that will render them non-exempt for that week, but that won't matter as long as they do not work more than 40 hours during that week. So it's important, if you're going to reduce the salary of a public agency salaried exempt person, that you do so along with a reduction in hours that make sure they do not work more than 40 hours per week. So that's limited to public agencies. It's a slightly different mechanism than what all employers can implement as well. And then finally, your doctors although they are exempt, they are not subject to the salary basis rule. And this is just doctors. It's not mid-level providers or FMPs. It's not PAs. It's just doctors. And doctors are not required to be paid on a salary basis. So you can reduce their pay, at least with respect to the Fair Labor Standards Act. Many of your doctors will have separate employment contracts, and they may require rendering this not an option for you, at least not without a renegotiation or of a temporary pay status for those doctors. So with that, thank you for your time. I'll turn it over to Christy.
Thanks, Brad. This is Christy Kimball out of the Salt Lake office, and I just wanted to quickly talk about elective surgeries and what's happening across the nation and in the various states in regard to those. I think everybody's clearly aware that in March, CMS issued recommendations related to postponing non-essential surgeries and other procedures. And what they provided was a tiered approach to determine which surgeries or procedures should be postponed, which should absolutely go forward, and then somewhere in the middle, those that needed to be more closely evaluated based upon the circumstances in your area with COVID and based upon the individual patients and their issues as to whether or not those should go forward. Some states have issued legal orders forcing providers to follow these CMS recommendations or a similar kind of order. One of those was issued by Utah's Department of Health on March 23rd, and that remains in effect until April 25th. Of course, as everybody is aware, these recommendations, these orders that have been put in place were done so to try and ensure that, one, we were preserving essential equipment and PPE for COVID patients and, potential surge in the hospitals, but also to make sure that we were not unnecessarily spreading, COVID-19 to patients that didn't need to come in, for certain visits or procedures right now. And so those were the two main reasons you saw that go into place. Of course, this has meant that so many healthcare systems and hospitals and surgical centers have this is a really big struggle for them because so much of revenue is created through these various surgeries and procedures that have just been brought to a halt in those places right now. And so this is causing a serious, financial strain on healthcare providers, but it's also obviously putting, patients at risk if procedures that need to happen aren't going forward, or if there's a delay in care. And so it's tough to figure out where that balance lies in terms of, postponing care, but also now getting patients in to reduce possible complications, morbidity and mortality that's unnecessary due to putting these surgeries or procedures off, but also ensuring that where appropriate, that physicians, dentists, surgical centers, hospitals can start generating some needed revenue through these sources as well. The one thing that I wanted to mention is apparently yesterday, President Trump said that CMS is finalizing guidelines to resume elective surgeries that have been postponed earlier. I haven't seen that hit as of yet, but as soon as that does hit, we'll make sure that gets posted to our website. But in the meantime, on April 17th, the American College of Surgeons, together with the American Society of Anesthesiologists, Association of Perioperative Registered Nurses, and the American Hospital Association, they did a joint statement that's a roadmap for resuming elective surgeries during this COVID-19 pandemic. And I suspect that the CMS recommendations will probably closely mimic this roadmap that's already been put out. But I suspect, in Utah, and I think Idaho's doing pretty well, but in Utah, the hospitals are doing really well in terms of their, level of ICU beds, hospitalizations. In Utah, we have a really young population. Our population skews very young, but for whatever different factors, I think there's several of them. But hospitalizations for COVID-19 in Utah and then deaths compared to other states have been relatively low. So what that's meant is that we haven't seen this surge that we were preparing for, which is why, again, the Department of Health here in Utah put in their order to say, please, follow the CMS recommendations. But now that we're not seeing that surge and the hospitals are pretty quiet to date, we are going to see, I'm sure at the end of this month, beginning of next month, I suspect that we'll see this order that was issued by the Department of Health here lifted, and then we will see some guidance come out from state leaders, and that will happen in every state in which you guys are in terms of based upon what's happening, how these elective procedures should be allowed to go forward. But in terms of following some guidelines, I want to just kind of hit the highlights of checklists that you should be thinking through as you're preparing for when that's available to happen in your state. Right now in your state, if it's not allowed, obviously, then it's not allowed. You've got to follow those CMS recommendations or whatever other order has been issued by your state. But to the extent, at some point in time that is lifted, I'm going to go through this joint statement that I've referred to at least give you an overview of what you should start thinking about. Now, this is going to, the facility readiness to resume these elective surgeries and procedures. The one key point is that this is going to vary, of course, by geographic location. So depending upon, how bad COVID-19 is affecting, various areas, various hospitals, this is all going to be determined by geography. So I just want to make sure that we're clear about that. But the following are a list of principles and considerations that were issued as part of this roadmap for the resumption of care for operating rooms and all procedural areas. So in this the first issue that's been identified by this joint statement, again, is looking at the timing for reopening of elective surgeries. And the first guideline is that there should be a sustained reduction in the rate of new COVID-19 cases in the relevant geographic area for at least 14 days. And the facility should have appropriate number of intensive care unit and non-ICU beds, personal protective equipment, ventilators, and trained staff to treat all these non-elective patients without resorting to a crisis of care standard. So that's going to be the first thing that you have to go through. And again, that's once the appropriate state, county, municipal health authority says that you can resume these elective surgeries. So that's the first standard. The second standard to be thinking about is the availability of COVID-19 testing within a facility. And so you've got to think about protecting, of course, not only your staff, but the patients in whatever policies you put in place, resuming these elective surgeries. And you've got to look at the availability of testing in your area, and based upon that, the frequency and timing of, let's say, patient testing. So, if there's enough testing available, it would be important, to have some kind of policy in place where patients where it's not an urgent surgery, but this is going to go forward, where there's hopefully some kind of testing criteria for those patients, and then having them quarantine for a time before their surgery to make sure that they are COVID-free. And the same would be true of staff, that hopefully, again, as testing becomes more available, looking at policies for testing staff on a regular basis to ensure that you've got healthy staff members that are involved in caring for these patients and not spreading COVID-19 to these patients. In terms of the next guideline principle to be considering is personal protective equipment. Again, you shouldn't be resuming elective surgeries until you've got adequate PPE and surgical supplies that are appropriate, of course, for the number and type of procedures that are going to be performed. So you've got to have some kind of system in place where that's being closely evaluated to determine whether or not you can resume these elective surgeries or procedures, and to the extent that you can do that. The next guiding principle is having some system in place for case prioritization and scheduling. So, this joint statement talks about a policy committee that consists perhaps of surgery, anesthesia, and nursing leadership to develop a prioritization strategy that's appropriate to the immediate patient needs. And as they go through and look at this, it's pretty extensive, but everybody should go through and look at this joint statement to start evaluating and putting in processes and policies for your facilities. But you've got to obviously look at a list of previously canceled and postponed cases. They talk about an objective priority scoring in terms of, creating some kind of scoring that helps determine which cases should be scheduled first. And again, we've got to decide, right, how to get these things queued up. They talk about a specialties prioritization, such as, cancer, organ transplant, cardiac trauma. They talk about a strategy for allotting OR procedure time, and I think what they're really getting at here is looking at block times and prioritizing which cases should go in which order. And I think that you do that in conjunction with thinking about the possible exposure for COVID, and making sure that as you have these processes in place, that you're thinking about block times where, the highest risk patients maybe, at the beginning of the day, and just deciding based upon the priorities of these patients, how they should be scheduled in these block times to protect everybody. Also, identifying essential healthcare professionals and medical device reps per procedure. Of course, in the past, you've had medical device reps in these procedures. You've had students, you've had residents, different people that have been observing. So you've got to have policies in place to really limit that and make sure that you only have the individuals that are necessary for those procedures in those rooms. And you should have a strategy for a phased opening of the operating rooms as well. So identifying capacity goal prior to resuming. Let's say that you want to have these ideas for when you've got certain data and you've got enough equipment. The COVID-19 in your area is low. Determining at what point and at what capacity you're going to ramp up. So let's say if right now you're at 10 or 15% caseload, at what point in time you're going to ramp up to 25% versus 50%, and be very careful about data that's going to trigger the increase of the operating room capacity. And you just need to make sure, obviously, that as you create those plans that you're thinking about, what primary personnel is going to need to be available to increase this volume and increase these hours. thinking obviously about your, surgeons, anesthesia, nursing, but even housekeeping obviously is critical right now. Engineering, sterile processing, making sure that you have the ability to provide all the required care as you're increasing or ramping up. And the next guiding principle is thinking about the issues for 5 phases of surgical care, and that you've got to have a process that really addresses the preoperative stage, such as determining, of course, patient readiness for surgery, the timing of reassessing patient health status. Of course, normally you've got to have, for CMS, 30 days, beforehand, you've got to have that full history and physical examination. But there are going to be some things that are going to be modified in this new stage, and with COVID, where you're going to have to make sure that that's done, in some cases, very close to surgery date, and again, in alignment with possible testing, if at all possible, to make sure that patients are COVID-free. And they talk also in this guideline about the use of telemedicine to do a lot of these things. So you're going to have procedures in place to really think about how are we going to do this in a way that whatever we can do for the pre-op assessments, we can do it in a way that's safer and not have as much exposure for COVID-19 to staff and to patients. The phase 2 is immediate preoperative. Phase 3 talks about intraoperative. And again, you can look very closely at this roadmap because this is several pages, so I'm just giving you the high level. But phase 3, intraoperative, as an example, they talk about, assess the need for revision of pre-anesthetic and pre-surgical timeout components, a guideline for who is present during intubation and extubation, a guideline for PPE use, a guideline for the presence of non-essential personnel. So there are obviously protocols that have to be modified for COVID-19 to reduce the possible exposure, and then also to ensure that we're preserving PPE. So you've got to make sure that you're modifying your present, what in the past, what guidelines you've had in place, make sure those are modified moving forward. And then also you've got to think about things like post-operative. You want to make sure that you're optimizing length of stay efficiency, decreasing complications as much as possible, obviously, so that we don't have patients ending up, having longer hospital stays than we hope, or hopefully being able to, as much as possible for some of these less complicated procedures, being able to discharge patients to the home where possible. And that's the last phase that they talk about under, the operative procedures, is really thinking about that post-discharge care planning. It's going to be really critical. You've got to think about, okay, post-acute, where would these patients normally be going? Would they be inpatient at our hospital for a time? Would we be normally releasing them to a rehabilitation facility, a long-term care facility? Right now, obviously, it's just not ideal to be discharging people into a nursing facility right now because the rates of COVID-19 are pretty hard hit in some of those facilities. So to the extent that you can put in protocols in place to try and reduce the amount of patients that will be going into certain long-term care or post-acute care where they might have a greater exposure, you want to be able to think about that and plan for that with the patients and their families beforehand as much as possible. And then, the last one is, one of the last ones is the collection and management of data. You've got to have a system in place to be constantly reevaluating the data and reassess your policies and procedures based upon what's happening with COVID-19 related data, resources, testing, and other clinical information. So you've got to make sure you've got to have that data collection and assessment policy in place. Next, it's looking at, COVID-related safety and risk mitigation surrounding a second wave. It talks about having facilities should have and implement a social distancing policy for staff, patients, and patient visitors in non-restricted areas in the facility that meets your local and national recommendations. And so obviously I think most hospital and facilities right now, obviously we've been really ramped down in terms of number of visitors who can accompany even, mothers who are going into labor. the people that are going in to have a procedure. So you've got to make sure you're looking at those policies and making sure that you're doing all possible to reduce the amount of exposure. And then this joint statement and recommendation talks about just other issues to be cognizant of, including healthcare worker well-being. This has obviously been a tough time for healthcare workers, so you want to be cognizant of that. But patient messaging and communication, case scheduling process, facility and OR procedural safety for patients, again, cleaning, preoperative testing process, looking at environmental cleaning as part of that, thinking about things like the re-engineering, testing, and cleaning as needed of anesthesia machines returned from COVID-19 patients versus non-COVID ICU use. So there's got to be a lot of things in place and processes in place to try and keep patients as safe as possible as we start to at least allow some of these more elective procedures in place. So I encourage everyone to go look at that joint statement and review it very closely. And then if you have questions or concerns, obviously we're here to help in that process, but hopefully in some of our states where we're just not seeing significant surges, hopefully we can all, work together after state authorities and county authorities allow us to do so, to start providing some of this essential care in a way that won't lead to significant risk for additional surges in COVID-19. So with that, I'm going to turn the time over to, I believe it's Jay DeVoy.
Thanks, Christy. This is Jay DeVoy in Las Vegas. I'm providing a quick update regarding the Department of Health and Human Services and its Office for Civil Rights and how it's been enforcing Section 1557 of the Affordable Care Act. For those of you who aren't familiar, Section 1557 of the Affordable Care Act imports a lot of civil rights laws and other laws that have to do with the protection of certain individual and human rights, such as the Americans with Disabilities Act and the Rehabilitation Act of 1973, and certain sections of them, and gives the Department of Health and Human Services, through the Office for Civil Rights, enforcement authority over those sections of law with respect to any recipients of HHS funds. This includes covered entities, facilities, and most recently states that receive HHS funds in responding to this kind of pandemic. The Department for Health and Human Services first made its announcement regarding its intentions to enforce Section 1557 in very late March, March 28th specifically, and immediately following that, a complaint was filed with the Office for Civil Rights with a number of human interest groups against the state of Alabama. At our last tele-seminar, we discussed what the enforcement action against Alabama entailed. An administrative action was commenced by the Office for Civil Rights against the state of Alabama with respect to prior versions of its crisis response plan that was still available online, and which indicated that certain prohibited classifications were considered in rationing and apportioning healthcare resources to people in the event of the response to the COVID-19 pandemic. As part of that resolution, the prior documents were taken off of the internet, so to some extent that was an incident of failure to maintain the website and better curation, potentially avoiding a complaint, and the state of Alabama disavowed its use of those prior guidelines and confirmed that they would not be binding on the current disaster relief plan. And to that end, there's been no update on that. But against that backdrop, other states have come within the crosshairs of OCR. Most recently, there was a release issued by the Office for Civil Rights on April 16, 2020, regarding an action that was commenced against the state of Pennsylvania on April 3rd, and by the 16th had been fully resolved without any further action being taken by the Office for Civil Rights. So for that reason, there's certain distinctions between the Alabama action and the Pennsylvania action that, in the case of Pennsylvania, make Pennsylvania more relevant to healthcare systems, health facilities, and other providers that might be delivering first-line care to individuals who are affected by COVID-19, and in the future, that bear consideration in any kind of plans that are put into place for the apportionment of care, or in the event that care is limited, if there has to be any kind of rationing for it. So the crisis standards of care that were adopted by the state of Pennsylvania drew fire from a number of groups, including the Disability Rights for Pennsylvania group, that complained to the Office for Civil Rights on the basis that certain individuals with identified disabilities or conditions They're not specified by the Office for Civil Rights, but they were specifically identified within the crisis standards of care that were adopted by the state of Pennsylvania. And those individuals were deprioritized for receiving ventilators and other forms of care. And on that basis, the Office for Civil Rights brought action against the state of Pennsylvania, and there were three key components to the resolution between the Office for Civil Rights and the state of Pennsylvania. Specifically, the state of Pennsylvania had to remove criteria that automatically deprioritized persons on the basis of particular disabilities. Now, what those disabilities were are not specified. However, it seems like the takeaway from this is that any specification of disabilities without an individual assessment as to that individual's care and prognosis is a red flag for OCR enforcement. The second is that the state of Pennsylvania and its guidelines had to require individualized assessment of each patient based on the best available, relevant, and objective medical evidence supporting triaging decisions. So again, the fact that somebody has a disability is not necessarily going to require them to receive care or disqualify them from care, but the Office for Civil Rights is requiring this kind of individualized assessment. And as I'll discuss in a moment, there are other conditions to that in terms of what the Office for Civil Rights warns about in terms of the implementation of these plans, even if they are facially neutral and call for this individualized care. But the Office for Civil Rights is most concerned at this point about sending the biggest message possible and the most visible message possible about making sure these kind of individualized assessments occur without making presumptive decisions based on anyone's disability or condition. Finally, the Office for Civil Rights required the state of Pennsylvania to ensure that no one is denied care based on stereotypes, assessments of quality of life, or judgments about a person's quote-unquote worth based on the presence or absence of disabilities. Again, this is an area that seems like it was informed by Title II of the Americans with Disabilities Act, which the Office for Civil Rights has authority to enforce. And the concern is primarily about individuals with disabilities being denied medical care without individualized assessment, and ensuring that the criteria that are applied for apportioning medical care do not use the subjective or particularized assessments of a healthcare provider in the place of a broader assessment that considers all of the criteria and a prognosis for the individual's specific outcome rather than making a generalization based on an existing disability or condition. And based on the state of Pennsylvania agreeing to these actions, the Office for Civil Rights took no further action and dismissed the complaint. Currently, this information isn't available online or broadly available, but it could be available in a few months within a response to a FOIA request for this information. Now, what is important, though, is at the end of the release that was published by the Office for Civil Rights was an indication, and as I discussed last time, that the importation of some of these standards, such as Title II of the Americans with Disabilities Act, the Rehabilitation Act of 1973, and other parts of the Civil Rights Act that were imported, such as Title VII and Title IX, that are enforced through the Office for Civil Rights under the authority given to it under Section 1557 of the Affordable Care Act, is that now this agency is going to start looking for disparate impact, not just in what the facial criteria are for making these decisions, but in how they're applied and who is affected by them as they are implemented. So the important quote at the end of this was from Roger Severino, the director of the Office for Civil Rights, stating that triage decisions must be based on objective and individualized evidence and not discriminatory assumptions about the prognoses of persons with disability. And he goes on to state, we must ensure that triage policies are free from discrimination both in their creation and in their application, and we will remain vigilant in achieving that goal. So the statement there about the application of these policies is where the likelihood of future enforcement action based on disparate impact comes into play. You can have facially neutral policies that do not take into account any kind of protected class or any kind of disability, but if they are applied in a way, even if applying the criteria that are contained within it in black and white letters in a way that adversely affects or disproportionately affects people from protected classes or with disabilities, then all of a sudden there is a problem where people's rights are being deprived based on policies that are facially neutral and they're being applied as specified because they disproportionately impact people who are of these classes that are meant to be protected by the laws. And looking forward, that is something that might be an issue that comes out of COVID-19 and these actions taken against the various states by the Office for Civil Rights. So that is something to follow. There's not enough indication of what will happen with that issue based on the actions that were taken by the Office for Civil Rights against Alabama and Pennsylvania. But reading the tea leaves of the statements that were issued in connection with the resolution of both of those actions, there's an indication that the Office for Civil Rights is looking more into its mandate to investigate and police potential disparate impact in the implementation of these programs that are funded by the Department of Health and Human Services. And with that, Christy or Kim, whoever wants to conclude us, I thank you for your time. Well, if nobody else has anything, thank you for your time. I appreciate your attendance today. It was a pleasure to speak with all of you. If there are any specific questions, please follow up with any of us who presented and had anything to speak about today. Thank you.